hearing of the ZBA, and the first matter on the agenda is the continued public hearing on a special permit request by Joel Aho relative to a property at 154, 156 Northborough Road. And at the last hearing, the applicant did anticipate that he'd file a continuance so that he could first go to some other different boards before he came back to us. We've already approved the variance. So he's already filled out a agreement for a continuance to some date in June, and it's just, what we just need to do is pick a date. Karen has suggested, these are all Wednesdays, June 13th, 20th, or 27th.
June 20th. Mr. Chairman?
Yep.
I make a motion that we continue this to 7 o'clock on June 20th.
Does that work for people?
Sure.
Second.
Who's second?
Go to second.
Craig is still checking his schedule.
Yep. All right.
Yeah, June 20th.
Okay, so we'll, I guess someone you made a motion that's been seconded,
Yep,
so
all in favor.
all those in favor? All those opposed? So,
Mr. Chairman?
hold on, yeah,
That's, Mr. Chairman, I make a motion that we have
It doesn't have that thing on it.
a few minutes recess here.
No, you have to do your extension of your decision deadline.
yeah, and then let's also take a vote on, the applicant agreed to give us an extension until July 15th of the time to reach a decision.
I move that we extend our deadline to reach a decision to July 15th, 2018.
I second it.
Does that, like, when would our July meeting be? In case we had to, like, discuss something before, should we?
We're meeting in June, so if we need to extend it beyond that, we can do that at the June meeting.
So we could extend, yeah, but we might not be able, all right, whatever. I mean, if we don't need to extend, but that might not be granted, you know what I'm saying? Like, when's the July meeting gonna be? Why don't we just extend it to that date, so then we have ourselves covered? In case that happens.
He's already, this is what we've got in front of us.
So we'll get it done on June 20th.
If we need to further extend it, we'll just ask for a further,
We'd have to talk to him
Extension.
about it.
At
probably
June
anyway.
20th, we will
Okay.
do it.
All right, I'm fine with that then.
Yeah, he's willing to extend it if you need to.
All right?
so let me just fill this out, 7 PM?
Yep.
And then Mr. Barlini, you had a,
Mr. Chairman, I make a motion that we have a
Want to do the minutes?
5 to 10 minute recess.
I want to read it a little bit more. Is there a second?
Second.
All those in favor? Okay. Okay, so we're back on, and the next item on the agenda is a discussion about Article 32 on the town warrant. And basically what this is a proposal to amend the Southborough zoning bylaws so that an appeal from a planning board action on site plan approval would not go to the ZBA anymore. It would just be directly appealed to court. So I have some context on this, and I attended the planning board public meeting on this, so I'm happy to give some background on it, if that's helpful.
Sure.
So, in the last, let's say, 4 years, there have been 2 of these types of appeals. One of them was the soccer field case, the Fay School soccer field
Yep.
case, which I think, Paul, you were involved in.
We did.
Yeah.
Yep.
And then the other one, of course, was the Park Central one.
Oh,
where
yeah.
the planning board denied site plan review, and then under the bylaw, the appeal comes to us. So for both of those, I had thought those are weird proceedings, because everything else we deal with is variances, special permits, Chapter 40B, appeals from building inspector, and there are clear standards for how we approach that. There's no real standard about what we're supposed to do when there's an appeal from the planning board. Are we supposed to just redo it? Are we supposed to look for some clear error? So I know, I have spoken with Aldo about this many times, and we've both felt that this is kind of odd. There's currently a lawsuit, in which Park Central versus ZBA, in which there's an appeal of our decision to remand the action on the planning board, the planning board's action on the site plan review, just back to the planning board. But at one of the initial hearings in that case, Aldo says that the Judge Karen Shire, said, that's odd that the town, Southborough, has a bylaw that has an intra-agency appeal, so that the ZBA is the appellate authority over the planning board for site plan approval. So this did set in motion. I think Aldo went to the Board of Selectmen and recommended a change to this. And I understand there has been a meeting about it at the Board of Selectmen. I don't know if there's been a formal vote on it, but Aldo's spoken up about it favorably before the Board of Selectmen. There was also the planning board, because the planning board has to have a hearing on any change in the zoning bylaw. They had a hearing, and I did appear in that, and I did speak in favor of it, but making clear that I did so just myself, and that the board hadn't taken a position on it. So this is going to be considered at town meeting on April 10th, I think, and I want to put it on the agenda so that the board has an opportunity to discuss it and take a position on it if the board wants to, because it's probably going to be asked at town meeting. What does the ZBA think about this?
And to make a recommendation that we send a letter to Paul Semino. On the
So
decision that we make.
I can talk more about it, but first, if you want to, I don't know if someone else has had the opportunity to look at this or think about it.
The major issue, I've been involved in the ones we've done for past 10, 12 years. And, I mean, they come to us, they get approved, most likely, and then we end up sending them back to the planning board. The major issue about this is, if it gets done to anyone, and they have to appeal it in court, it'll take them anywhere from 14 to 16 months to get into court, and it'll cost them anywhere from $20,000 to $30,000 just to get it done that way, which I personally feel is very ridiculous to do to the residents in the town of Southborough. By us taking it as a zoning board and then sending it, approving it and correct it, but sending it back to the planning board to finish it, is still leaving the planning board in charge of it, after the fact. So,
Paul, do you have any questions, or?
I understand why you're saying it's quirky in nature, but if I'm following correctly, the essence of it is that on a 40B, it's coming to us.
Exactly, so this does
And
not
then there's
deal.
a certain component, well, in the case of, like you said, Park Central, if we're citing that as an
Well,
example.
But that had to deal with the Park Central use variance. okay?
Yeah, that's
And
the
there's some-
40B.
Right, well, the 48 component of it,
So when you were on the, you, David, and Lee were on the board to consider the 40B application,
uh-huh,
you basically did a site plan, a
Correct.
review of the site plan and the landscaping and of certain parts of the site.
The whole
Right.
site.
So this isn't about 40B where my.
well, I'm just saying that the quirkiness is there was some component of it that was in front of us, and some
Yes,
component that goes
That's right.
to them. So I think, I don't know, I just think it's not that quirky because there should be, I guess, because you had two entities reviewing the same overall project, so to say. So I'm just saying that's why I guess why it exists. So it's not, I don't think it's that to me doesn't seem that bizarre, I guess, but.
The issue that made it so, the way it is and what Paul is saying, is the use variance that was done on Park Central was done under the control of the 40B. And we voted to do that, and we controlled the site plan and review of all that. You know, and that's something the planning board didn't want us to do, and that's what caused all the legal issues with the planning board and everything on that particular item, as far as Park Central went.
So another way I've thought about it is that when there's an action on site plan approval, right, it's either approved with conditions, and that's supposed to be 99% of site plan approvals, or there's a denial. And a denial is a pretty significant move. It's gonna be controversial. So in that case, there's gonna be a serious legal question. Why submit that serious legal question to us? Why not just have it go directly to court? And I felt that it's kind of awkward to handle the Park Central appeal that we did. It did not, the folks who are against this say it's gonna lead to more litigation, right? Because then people are gonna have to hire lawyers. And what we did in Park Central didn't avoid litigation. There's still a lawsuit about it, right? So when there's a denial, I think, the planning board, there should be an appeal directly to court. And then the planning board, basically Aldo would represent the planning board rather than us. And if the planning board felt that it was proper to deny it, then, the whole point of the case would be to see whether that was correct or not. If it's just an approval with conditions, like the soccer field case, when we decided that, my feeling was, why are we really doing this? There was nothing seriously wrong that the planning board did. It was just another try to get like a slightly better deal. And if you remember, the record in that case was like this thick. So if you were to really do your work and look into all of this detail, to redo the site plan review, it's a lot of work. And I think that it just duplicates the work that the planning board is doing. So I think it's something that could by just separating out some of the jurisdiction of the planning board and the ZBA, we can reduce some of the kind of conflict we've had over the past couple of years. So I'm in favor of it. And I did also prepare an amendment that that Aldo has reviewed, and it's basically just to, I think, improve the wording of it. And that's what I've circulated. So, does anyone else have any questions or comments?
So, I understand what you're saying in terms of like major site plan review and the record and all that sort of stuff, and I wouldn't necessarily think of us as, relooking at things for, road widths and stuff like that. But there isn't anything that differentiates between the guy wanting a sign and a major site plan review in this. And the small business owner that wants a sign done that they just say no, even though it may not be, whatever the case might be, their recourse is now litigation. Their only recourse is litigation. And so, for those types of things, which I mean, you gotta admit, most of the stuff that anyone's gonna, 99% of the stuff that people come to us with is going to be more along that vein than the Park Central vein.
So one, this response to that is, so this was passed in 1980, if the zoning bylaw was enacted in 1984, at least what Aldo has said is the only two appeals that have been taken since 1984 under the section are the two that have come before us recently. So, you know, if it's the case that a neighbor who doesn't like where the planning board allowed trees to be built on a site plan review could, you know, come to the ZBA to tweak the site plan a little bit and, you know, wouldn't have to hire a lawyer to do that. That's actually just never happened before. So, you know, there's a legitimate question there. Okay, do you change the bylaw so that that's no longer a possibility because it's never been used? Or do you get rid of it? I think it's worth getting rid of because in the more major cases, it's worth it to just have, it's an issue between the developer and the planning board, not really the ZBA. And I really don't like the part of the current bylaw that basically says the ZBA can either, you know, it has the power to, if it wants to, just completely reopen the whole thing. That's something that we faced in the Park Central, you know, appeal, right? And that would involve, I mean, it may be a possibility, is we then reopen the entire thing, and that would have taken a long time and would be duplicative of what the planning board has already done. And at least I can say, you know, over the past 4 years, I've gotten more experience. It's, you know, the special permit variance, building inspector appeals we've done, but I really don't, I'm not as sharp on some of the site plan criteria, but stormwater calculations and parking and things like that.
I agree with you there in that is their area of expertise, but I do still find it that having the only recourse for somebody to sue the town, you know, it's a high barrier of entry for anybody that just doesn't agree with what the planning board did. And it's a lot of authority. I mean, if you know that the only way that somebody can question your decision is to hire a lawyer and sue the town that they live in, there's not really a check to balance what they're doing that is reasonable for everybody in town. I mean, if the bylaw needs to be amended where we're not reopening an actual site plan review, but we're only reviewing the procedure that the planning board went into, that's a different story. And that, I think, that is probably more what we should be doing. But to just flat out say the only way you can ever question a site plan review from the planning board is to hire an attorney and sue the town, I think
You don't necessarily have, I mean, you can represent yourself pro se, but
yeah,
admittedly, you're gonna be a lot better off.
you know the saying, you're an attorney. So,
The other issue that could be done, and it could be changed, is if you leave this article the way it is and you approve it, you add a condition to it that the residents of the people who do the lawsuit are not legally charged the money for doing it, and let the town pay for it to go to court for the residents of the town of Southborough.
Well, since this is, the town meeting is happening on May 10th, the procedure to,
April
Ninth?
10th? April 9th.
April 10th, the
Ninth.
procedure to do amendments, April 9th,
Yeah.
there's just not enough time to, you know, do a serious redo of it. So,
Yeah.
so I guess I'll put it this way. I don't know if there's a consensus or if there's not a consensus or if we want to take a position or we not want to take a position. We don't have to take a position if we don't want to. David, do you have?
I think I'm more inclined to agree with you, Andrew. I find I understand the ZBA's role when it comes to zoning code enforcement and violation. particularly where you say you can find pretty easily 3 towns that have a similar bylaw. It seems like a little bit of a stretch to have the ZBA take the planning board's decisions and say, no, that was incorrect. I understand the argument for appeal, but I understand the conflict as well, and what would drive this change in the bylaw.
Well, it also forces you to think, if you don't have a really good appeal, and there's not really that much at stake, then maybe you don't take the appeal at all.
Right, and I mean, if what you're saying, what Aldo is saying is, in the course of how many years? It's been 2. I mean, it'd be one thing if you said you're eliminating it and nobody has any recourse, but you're being, the language is really specific here, right? This is site plan review.
Major site plan, minor site plan?
It says
Everything.
site plan.
Everything.
But I mean, if it's a minor site plan, I think the way minor saying, yeah. Do you want to get the microphone and?
As a resident?
You can take the,
Is that working, ma'am?
Speaking as a planning board.
I can't hear it, but it was on.
Try this one.
Try this. Mimi, just say if you're as a resident or planning board member?
Yeah, as a member of the planning board, Mimi Luttrell. Just the minor site plan goes to the department heads, and if there's an issue there, if the proponent is unhappy, then it goes to the planning board. So the appeal kind of there is to the planning board. So this would only be major site plan.
which I think is, what is it? What's the square footage? There's, building, is it more than 20 parking
20
spaces and 2,000?
2,500.
20,000 square feet or
No, it's not.
2,500, I think.
5,000?
How much?
I think it's over 2,500, but don't quote me on
Okay.
that.
I wanna say it's 2,500. I was on the board when we approved that. And I wanna say it was 2,500 square feet.
Yep.
Anything below that went to that other special committee.
Yeah,
Anything above that had to go to full planning board review.
So basically, any house in Southborough would have to go,
not mine.
Not mine.
well, yeah.
So, just another comment I
The
would,
house wouldn't be a site plan, though.
another comment I would offer that I've discussed with Aldo is there's kind of a sense that, over the years, there have been a couple times where there's litigation about a part of the zoning bylaw, right? And it becomes apparent to the town council, okay, this part of the bylaw is problematic. A couple times there have been brought forth proposals at town meeting to just tweak some portions of the bylaw. And it's frustrating how just a couple times at town meeting, there's been action, no, we don't want to do this, we don't want to do it now. There was a comprehensive permit to try to redo the whole town zoning code and modernize it, that lost momentum. So, I mean, where this is coming from is trying to look ahead and see areas where if we just modified the bylaw somewhat, it would reduce legal problems for the town going forward. So I hope people understand that's where it's really coming from.
But if the only recourse is court, does that really reduce legal problems for the town?
Well, I guess I'll put it this way, a legal problem that Aldo has right now, and I think he's in a difficult position, is, so he represent, in the Park Central versus ZBA case about our decision to reverse and remand the Park Central matter back to the planning board, who does Aldo represent? He represents us, but there are some kind of nuances between our position on that and the planning board's position on that. I think the planning board feels like it's basically an appeal from their decision. They would prefer to have town council represent them and defend the decision they made. And if that's the case, then if that's what it's really about, then maybe it makes town council's job simpler to just say, okay, you know, it's an appeal directly from the planning board action, town council will represent the planning board. And I do also think that if if, you know, like on our cases, we know that if, you know, if there's an issue with that decision, there's a chance it's gonna go directly be reviewed by a judge. And I think we are, you know, conscious about trying to get the right legal standards applied and stuff like that. And I think that amending the bylaw so that on site plan approval, there's direct judicial review of planning board actions, at least those that are denials, I think it focuses the planning board more on making sure the decision follows the right legal standards and things like that.
The only thing that is legal is that in a 40B project, they have no control or say on it at all. They can make a recommendation, but that's it.
Well, that's a different concept. So
Right.
that's not really what's being discussed or what this is about.
Except for they're saying it because of the use variance that's on Park Central.
So do you guys want to take a vote yay, take a vote nay, and haven't made up our minds? I mean, another thing we can say, we just discussed it and didn't really come to a consensus position.
I would say we don't really have a consensus position based on the discussion. So I'm not sure we're in a position to say this is the position of the ZBA.
Okay, Lee, what do you think?
I think that if separate or individual board members, that what if we just make a recommendation that any member of the board wants, can say what they want at town meeting about it?
As an
As
individual,
an individual.
That's right,
I think
But I
that
think
sounds
we
good.
have that right anyway, don't we?
without doing a vote. So we make a motion to do that as legal.
Fine.
Can't we speak at town meeting as
Yeah,
individuals
I'm
anyway?
not sure what that does.
I think we can, but this will affirm our commitment
Yeah,
that we each can
it's just
speak
restating our
as
democratic right.
individuals at town meeting about what we want to talk about. So if you want to make that motion, I'm fine with it. Or
I don't think we need it.
Okay.
I mean, personally, we're all entitled to speak our mind as individuals, and no one is,
No,
you
the
haven't
motion-
authorized anything to have anybody stand up and say they're speaking on behalf of the zoning board, so I don't think we really need a motion that says we can all go up and speak on behalf of ourselves.
The statement of the motion is, then is the board going to vote in favor or against it now?
I don't think we're even taking a vote.
Yeah,
We're not,
Right,
we're
so
not
that's what
deciding anything.
My motion is that, I mean, I'll read the motion and you deny it. That I make a motion that we do not vote on this, but we have the right, if we want, to speak at town meeting about it. That's it, simple.
I'm
So
fine with that.
clarifies us not making a vote and just publicly stating that we can speak at town meeting.
I have a comment, but there's a motion up for a second if anybody wants to do it, so,
Did that get a second?
not yet. I think it's not gonna get a second. at the
could you
moment, so-
restate,
I'm just saying because I don't think, I agree with you, Craig, it's not necessary.
Could you
It's not
restate-
necessary, but I
Lee,
think,
could you restate that? I didn't, so you're,
I can withdraw it if you'd like.
Okay.
Well, I just said it didn't get seconded.
It just sounded to me, whatever you said was rather innocuous, that it didn't, it just says we're not gonna vote and we can just,
Yeah,
yeah, so
so sure, I'll second that we're not gonna vote. I don't, I mean,
Is that formal? Yes, second.
and then you wanna make a discussion about it? Is that,
no,
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 there's no
so,
discussion about it, I just had a comment elsewhere. So,
so I guess you've seconded Lee's motion, so we'll just, all those in favor? All those opposed?
All right, so,
Okay. 2-2-0, I think it fails. Lee abstained.
hold on, I need to know, the two that were for were
so we voted that we're not voting.
Andrew,
We-
Dennington, and who?
we denied the fact that we're not voting
Who
and that
just-
we get to
Who
speak.
just voted for that last one?
Paul,
Paul and Andrew?
Yeah.
Okay, so Paul DePrenos, and then against were
Craig and David.
David Williams and Craig Nicholson. And did anyone abstain? Leo? Where
Lee,
was Leo?
Lee.
Leo.
So the only
made
other
a
thing we
motion, but you
can
abstained?
talk about is
So someone will ask if the zoning board had an opinion.
And if asked, I'll say that we discussed it and there was not a consensus opinion, and that we actually, individual members have different views.
Okay, do we need to vote on that? I don't think so.
No.
I don't believe so, no.
Okay.
So
Is that the end of the discussion?
the only other thing we can talk about is, apparently there are no other new applications in the pipeline. So we don't really have anything to consider until June, but, does it make sense to, we won't even notice this, but just to put as a placeholder date, make sure it's a date that works on our calendars of Wednesday, May 16th, so that if anything, someone was to file a new application in the next week or two, that's what we would aim to get it on the agenda for May 16th.
I may be out of town on May 16th,
That the end
but
of
we're
this-
not meeting
16th.
anyways.
We got the
You're right.
23rd.
But if we
16th
had to
works for
meet,
me.
I mean, it's free for me right now.
Mr. Chairman?
Yep.
I'd like to make a motion to approve the minutes for February 28th, 2018.
Second.
All those in favor?
Aye.
Okay, so just getting back to our discussion about a May date, are we
Yeah.
gonna, this is just a placeholder, right?
16th works as a placeholder for me.
Okay, but I think it doesn't work for Paul, so.
it may not.
If okay, we just put it,
Sure.
all right. I don't think we have anything else to discuss at this point.
I move that we adjourn.
Is there a second?
I would certainly second that.
All those in favor?
Excuse me.
Oh.
Karen,
A
do you have
discussion.
anything else?
No, that's it. That's it.
Okay, all those in favor?
That's it.
Aye.
Aye.
Andrew, could I get a copy of your amendment?